Greetings to you members. Welcome back to Agora Legis, the platform of legal minds, where we discuss legal principles and make them easy to understand for everybody. And today we are hosting one of the best tutors at law school that we know today, and which is Mr. Trezy. Welcome back to Agora Legis, sir.
Thank you very much. Thank you for this opportunity. Once again, my name is Mr. Trezy, and I'm honored to come here and extend legal knowledge to a variety of law students. And yeah, thank you for that opportunity.
Thank you so much, Mr. Trezy. So he is going to be taking us through legal methods, and we shall look today at the topic of statutory interpretation. We shall look at the rules of statutory interpretation and the rules of language while carrying out statutory interpretation. And without further indulgence, if you're serious about understanding the principles, I urge you to like, subscribe, and share to the channel so that you don't miss anything while preparing for your papers. So, counsel, tell us, before looking at what we call statutory interpretation, we have first to understand what is a statute. So, can you briefly tell us what is a statute? We have to understand the meaning of a statute.
Thank you very much. A statute, the literal meaning of a statute, the layman's meaning is this is a written instrument enacted by the parliament, and it's passed and it becomes law. So it's also known as an act of parliament. For example, we have a lot of statutes. For example, the Penal Code Act and a variety of other statutes, Contracts Act, the Evidence Act, and all that. Thank you very much.
Thank you so much, counsel. So, members, you guys are understanding what is a statute. And now we are going to look at what are those rules that we are going to apply when we are interpreting a statute, when we are carrying out interpretation of a statute. So, counsel, what are those main rules that the court shall rely on or use while interpreting the law?
Thank you very much. As we are digesting what we call statutory interpretation, I would like you guys to be addressed by the meaning of what is statutory interpretation. And statutory interpretation is defined to mean giving words their meaning or interpreting words in a statute. That is what statutory interpretation is. And as other statutes are, words should be interpreted in a statute. However, we are now looking at statutory interpretation. However much a constitution is a statute, you understand, and it's a law, we have also to know that the court that has the jurisdiction to interpret statutes, and that is the Court of Appeal, sitting as a constitutional court that has the powers to interpret a statute. Thank you very much.
Thank you so much, counsel. So, guys, I hope we are really following and understanding what is now statutory interpretation. We have seen a statute and the interpretation of that statute and what it means. So, counsel is now going to take us through the next point of contention, which is those rules that are applied while carrying out statutory interpretation.
There are various rules. We have three types. The three rules. They are also known as the canons. They are also known as the primary aids. They are also known as the rules or the principles of statutory interpretation. I already addressed you guys to the court that has the jurisdiction. That is pursuant to Article 132 of the Constitution of the Republic of Uganda. It gives that court, the Court of Appeal, sitting as a constitutional court, to interpret words in a statute. So we go to the rules. We have the three. We have the literal rule, we have the golden rule, and we have the mischief rule. Let me talk about the literal rule. The literal rule talks about a lot of things. First of all, it talks about that words in a statute should be given the plain, ordinary, and natural meaning. In that, if you see a word in a statute known as a leave, you give it its plain meaning. You understand? But however, there are a lot of jurisprudence or cases that have come in and applied the the literal rule. But most cases, the literal rule brings in absurdities. For example, we have various cases. For example, we have the let me start with the jurisdiction of Uganda. We have the case of Theodore Sechikubo versus Theodore Sechikubo versus the Attorney General. Thank you very much. They were interpreting a word called leave. You understand? So it brought a lot of absurdities. You understand? But however, we also have a case called the Fisher versus Bell case. It is a very, very good case in contracts law, talking about what we call invitation to treat. Yeah. So I won't discuss the brief facts, but I just wanted to show you how courts use the literal rule. There was what we call the Restrictive Offensive Weapons Act of 1959, and it was talking about the fact that no one had the right to sell a freak knife. It was really offensive, and you had penalties for that. But however, there is a distinction between an offer and an invitation to treat. The person just displayed that freak knife. It amounted to an invitation to treat. He did have the intention to sell it. You understand? So the courts had to interpret it, had to interpret the word contract of sale, because it was bringing in an absurdity, and they used their plain natural meaning to interpret that the freak knife. What amounts to a freak knife? They had to apply words in a statute or words in that Offensive Weapons Act. They gave that word its plain and natural meaning. They had to use it, and however, the other rule is also known as the golden rule. Most people call it the purposive rule. But the thing is, before we go to that, we should know that if the literal rule creates an absurdity, we then go to what we call the golden rule. Thank you very much. If the literal rule creates absurdities, unclear things or unclear intentions of words in a statute, then courts have to derive what we call the golden rule or the purposive approach. Thank you very much. But this was emphasized in a very famous case called Gray versus Pearson. The golden rule is also known as the Lord Wellsdale rule. It was emphasized in that famous case called the Gray versus Pearson. And here, they applied the literal rule, or the plain, or the natural meaning of the words in a statute. But these words in a statute caused absurdity. So they had to bring in the purpose, or they had to clear that absurdity. That's why they brought in what we call the golden rule. The golden rule comes in just to clear the absurdity caused by the literal rule. Thank you very much. So that is the easiest way to understand these principles. Is that the literal rule and the golden rule work hand in hand. But the literal rule gives the words their grammatical meaning. The literal rule, it gives them the grammatical plain meaning. If a word is boy, they give it boy. It is that word. But however, if that word creates an absurdity, then they have to bring in what we call the golden rule to clear that absurdity caused by the literal rule. Thank you very much. Let's dive into what we call the mischief rule. The mischief rule is also known as the Haysdon case, because it was emphasized in that case called the Haysdon. But however, the mischief rule talks about three things. Mischief means problem or a defect. It talks about what was the cause of that defect. Why did the legislators aim at, what was their aim at curving that problem? And it talks about mostly the intention of the legislators in curving that problem. So there is a case, there is a good case called the Smith versus Hedges. In this case, the prostitutes were chased from the streets. But however, when they were chased from the streets, they went to carry out their activity from the balcons. So for them, they were quotation in court that, you know what, you had chased us from the streets. You understand? So you had chased us from the streets, and we are not on the streets. We are now at the balcons.
balcons.
Now, how can we be liable? However, they had to use the mischief rule. What was the aim
The intention.
what was the intention of the legislators on bringing in such a law? Their aim was to curb prostitution. So they had to chase them even at the balcons, because the aim, they used the mischief rule to curb the defect, the problem. They wanted to remove prostitution, even though you had to go to the balcons, or you had to carry your prostitution in your homes. The aim of the legislators was to curb prostitution. However much they did elaborate effectively that you shouldn't carry out prostitution in all the places, they just said that all prostitutes are removed from the streets. Their aim, courts had to apply the mischief rule to understand what was the aim of the legislators and to curb the problem or the mischief. Thank you very much. So those are the three rules. They are very easy to understand, in that the examiners want us to know when we are curbing this topic. They want us to know what is a statute. You understand? A statute, which courts have the jurisdiction to handle such cases, including interpreting statutes. It is always the Court of Appeal, sitting as a constitutional court, that has that jurisdiction. And I've talked about the law that it's under Article 132. Then we have to dive in. Most people don't know how to distinguish between the rules of language and the canon. But right now we have just talked about the rules of statutory interpretation, the canons, the principles, or the primary aids of statutory interpretation. But however, there are only three, and that is primary. We have the literal, the golden, and the mischief. Now we have an interesting topic under statutory interpretation. It is also known as the rules of language. Rules of language. Which language do courts use when they are interpreting words in a statute? That is what I can tell you about. We have the rules of language, and we have the 4 rules of language. We have what we call the jus dem generis, we have the nocita associs, we have the parimateria, we have the expressio unis es exclusio alterius. These rules of language are used by the courts to interpret words in a statute. However, these rules of language are also key if at all they give you a bio question on statutory interpretation. So the rules of language include the jus dem generis. What is the jus dem generis? A jus dem generis, the literal meaning is same kind. You understand? If specific words of the same kind are followed by a general word, you understand? That is the thing called the jus dem generis. That specifically, a list of specific words is followed by a general word or general meaning. For example, if at all a signpost tells you that it's only dogs, cats, rabbits that are allowed in a park, you understand? It doesn't mean you to bring wild animals. The specific list of words is showing you that the park needs only domestic animals. The same kind. And for you, just because you have seen the word other animals, you want to bring in a wild animal. Courts will use that rule of language called the jus dem generis, meaning same kind, to interpret the word in a statute. And it was also emphasized in the famous case of Powell versus Kempak. It will also show you how courts use the rules of language of a jus dem generis to extract meaning of a word that had caused what? Absurdity. So we have also the nocita associs. The nocita associs is it means known by their associates, or it is also known as known by the surrounding words. For example, you know, when we're in O level or A level, there is a passage that was there. They used to put a very hard meaning of a word. You understand? And they would tell us to generate meaning of that word. But however, for us to generate meaning of that, we had to first read on the words before and after to get to know what does that word mean. You understand? So nocita associs is to the effect that to construe a word, you should to construe a word that is absurd and creates uncertainty, you have to use your other surrounding words to constitute meaning of that word. You understand? We also have parimateria, however much it's not used, but parimateria is to the effect that a prior act, if a prior act, it also means subject of the like matter. For example, if a prior act talks about the same thing, if a prior act talked about the same thing, courts can use that prior act to constitute meaning. You understand? For example, if at all there is a prior act, for example, the Penal Code Act, let's say it's a prior act, it was there before, then we have the Evidence Act. So if there is a word in the Evidence Act that is causing absurdity, but it was clearly stated in the Penal Code Act, the previous act, courts can use that the Penal Code Act to constitute meaning to that absurdity. Yeah, I think that is also known as parimateria, subject of the like matter. We also have the expressio unis est exclusio alterius, that says what?
Saying one is excluding the other.
Excluding the other. Thank you very much. For example, there are words of the same kind. If words of the same kind, all the specific words that are put in the statute exclude the others. You understand? If the words in a statute, they are telling you to, maybe let me give you an example. If words in a statute are telling you to bring, to maybe, if at all you have to attend a function, you have to put on suits, it's excluding the casual wears. You understand? That is bringing in that words of the same kind or words of specific words exclude the others. That is it. That is it about rules of language.
Thank you so much, Counsel. So, members, we have seen a lot about rules of interpretation and statutory interpretation. Counsel has talked about a lot, like rules, definition of key concepts, and we have seen what amounts to those rules and the rules of languages. And we have seen that there is a difference between the rules of languages and the rules of statutory interpretation. I urge you to subscribe, like, and share if you're serious about understanding the concepts and at Agora Legis. Thank you so much, Counsel, for accepting the invitation to come and discuss for our people and extend the legal knowledge.